Dr. Jacobs was talking about standard setting, and so now we're going to have a panel to look into that and look at the different angles within it. And so I want to first introduce Adam Mossoff, who, as you know, is the founder of CPIP and professor of law, and he is going to get us started with a presentation. Adam?
Thank you, a founder, yes. So thank you very much. I hope you enjoyed the lunch keynote speech very much. Sorry, I was having lunch was a huge fanboy moment for me. That's how you know you're a geek. So I'm feeling a little verklempt at the moment, as used to be said in the Saturday Night Live skit. But I will jump into my talk. So the use and abuse of standard development organizations. So I want to talk a little bit about how standard development organizations came about, what they serve for us, and ultimately some of the issues and concerns that we're seeing today from a slightly different perspective than what we heard from, for instance, Professor Sickelman and from Professor Barnett earlier today. So, but first I just kind of want to step back and just kind of assess, well, what do we mean when we think about standards? Because typically when we talk about standards, people think of like our smartphones, whether your Samsung Galaxy or your iPhone. They think of USB. This was developed by a standard. You even hear references to plugs. That certainly was a standard. But they don't realize how ubiquitous standards actually are. They are in everything. Everything that we use has a standards behind it, achieved through one way or another. So a classic example that I love to talk about is something nuts and bolts, screws. There's actually a standard for the depth of the screw that was decided upon. When you think about it, that makes sense, right? Because if everyone's buying screws and each screw has different depths for the actual part of the screw, none of the screws would necessarily work. But why can you go to Home Depot or Lowe's or an Amazon or anywhere and buy screws and know that they will work in the bolts that you have is because those are standardized, right? Another example is fire hydrants, or more specifically the connectors for hoses for fire hydrants. This actually came about from the 1904 Baltimore fire. This is actually a story that a lot of standards development organizations like to tell. So that there was a fire in Baltimore in 1904. It's a very serious fire. Much of the city burned down. And so fire trucks were brought in from other towns, but they couldn't connect their hoses to the hydrants in Baltimore because they had different size connectors in their fire hydrants than the hoses had. And so what came out of that was a standard set was set by a standard setting organization, a standard development organizations for all connectors for hoses to fire hydrants that they have followed ever since. And then last, but certainly not least, is shipping containers, right? So this is a really cool story. So I don't know if you realize, but so the way that ships were being packed for international trade and shipment of goods across the world in the 1930s was the exact way that ships were being packed and goods were being shipped as they were in the 13th century. The exact same way. This was a massive innovation that was the result of a trucker whose name is Malcolm McLean, who comes up with the idea of a standardized box that you can ship. Or you can use, you can put all these goods in, and you can put all the boxes onto cargo ships, and they take up a certain set space, and you can design cargo ships for these spaces, and it doesn't matter if you're shipping cars, or if you're shipping t-shirts, or if you're shipping screw nuts and bolts, or light bulbs, everything will go into these things, and you can have standardized, mechanized, and automated shipping yards. In fact, there's a really cool book about this called The Box, and chapter 7 of The Box, that's also how you know if you're a geek. You love books like this, right? So, chapter 7 of The Box is all literally is about the standardization debate about all the different organizations and the negotiations between truckers and railroad companies and shipping companies about what size and what would be the weight ratios and everything for these, all their different negotiations before they eventually settled on a standardized size of shipping containers. And by the way, really the theme of The Box is this is what made possible globalization. Right? The massive benefits from global trade in the late 20th century were all made possible by Malcolm McLean's invention of the box, the shipping container. But his invention of the shipping container wouldn't have worked if it hadn't been standardized, right? So standards are a universal feature of every functioning innovation economy throughout the entire world. Why are there standards? Because there have to be standards, right? Because when you come up with something new, right, your biological and technological distinctiveness will be absorbed into ours to create a new unified whole. By the way, this isn't a modern phenomenon in the 20th century, right? People actually started talking about standardizing machines, products, even services as early as the 19th century, because that's what happens in the 19th century is when you start to shift to national and international economies. So when you have that the explosion of products and people are now using goods outside of their villages, people need to start to understand that there are efficiencies that are to be gained by having standardized products, services, and especially for manufacturers, having all along the value chain standardized foundations, right? So how would standardization come about? Well, Jonathan Barnett this morning, he talked a lot about the great economic discussions about this, about the benefits and the efficiencies or whatnot. But as I said, it arose in the 19th century. But no one's actually talked about how we actually get standardized norms in the marketplace. Now, there are actually several different ways. One way is what sometimes referred to as a de facto standard. I'm old enough to remember IBM compatible computers. Who here actually had an IBM compatible PC? So it's everyone who's over the age of 35 or 40. Right? Right? I remember buying these, and eventually I said, I'm not going to get an IBM compatible. I'll buy an IBM. So I got an IBM Model 2, Model 30, PS2 Model 30, which had a whopping 20 megabyte hard drive. I was like, I'm never going to fill this up in my entire life, right? But another example of a de facto standard. So this is a standard that's not set by an organization ex ante. It's set just simply because a large company or just a product is issued in the marketplace and everyone gravitates toward it, and that just becomes the foundation. Another example is the QWERTY keyboard. Right? There's no organization that ever decreed QWERTY was going to be the foundations for keyboards. It just evolved because that was the nature of the keyboard that gained prominence. Another example is one that, of course, Jonathan Barnett mentioned, which was AT&T, which was actually on the foundation of its legal monopoly, but that's a story for another day. Another way that you can actually get standards is through standards wars, right? And I don't know if you can see who these two people are, but this is one of the very first standards wars that we actually had. So there's not just patent wars, there's standards wars. This is the fight between alternating current created by Tesla and direct current invented by Thomas Edison. And of course, that got translated into the fight between Westinghouse, which purchased Tesla's patents, and General Electric, which purchased Edison's patents, right? And by the way, they knew the reason why this was a standards war as well as a patent war, because it was a patent war as well, is because this was actually the very first platform war. Because they knew as early as the late 19th and early 20th century that whoever defined the basis for electricity was going to be, because electricity was going to be used in everything. This was the basis of it. This was a platform technology. So the debates and arguments about platforms today that you hear about on the internet and other contexts, nothing new, right? So, but this isn't the only standards war we've had. We've also had, the Blu-ray versus HD DVD was a standards war before, where you actually had different products being sold in the marketplace, because the different organizations for setting the standards, as you heard from Dr. Jacobs today, sometimes take a long time. So the companies decided to go into the market and try to win by just through a predominance of their purchase of their products and become a de facto standard before a standard was set. And another famous one, of course, is VHS versus Betamax, and so on and so on. So, of course, is there any way that you can avoid these two alternatives, right? So is there? And to paraphrase, Yoda, there is another, right? That we have still hope, right? And the hope is, and this is why they were developed, is standards development organizations, right? Standards developers organizations. So these are classic stories of private ordering solutions to what are suboptimal alternatives, which is when you have either a de facto standard being set for reasons other than why people would want that standard, right? Because that's set either because of the market power of the existing company that actually creates it, or through just some quirk of the development of some product, like in QWERTY and things of that sort. You can actually have greater optimality achieved and the greater efficiencies achieved if the people who know what makes a standard good, engineers right? The people with that knowledge can get together and actually talk about, well, we should all kind of develop this as a standard. And these, I'm emphasizing electronics here just because this is what most of us know of through the standards, but this is true in all areas, as I said, in medical devices and transportation with shipping containers and trucking and tools and everything. Even I found a picture of one of my very first laptops I ever owned, a Toshiba 3700 with a click-on trackball, right? These were standardized technologies that were developed through standard organizations. And in fact, this is the classic, for those of you who know economics, this is a classic Coasian explanation for this, right? The Coase theorem, right? So you have bottom-up private ordering to address what is a transaction cost problem, because the lack of standards creates transaction costs for consumers and manufacturers in the marketplace. And so how do we lower those transaction costs? Well, you do the same thing that people do for creating corporations, or for creating patent pools, or for creating every other type of corporate structured device that reduces transaction costs and people getting together to agree on how to deploy a service or a product in the marketplace and get it in the hands of consumers. And that's exactly what standard development organizations do, in the same way that corporations reduce costs of manufacturing to get products and services in the marketplace cheaply for consumers. So they, and then everyone benefits from this. And the proof is in the pudding that this worked. Standards development organizations proliferated in the 20th century like crazy. And as a result, we got these massive, incredible products and services as a result of this. And this all occurs in the background, right? You know, your only experience of an SDO is that little paper packet that you get, and every time you buy a new product or service or device that you look at and you can't read it and you just throw it away because you're like, this isn't important. Well, if you actually take a look at it, it's a listing of all the standards that product represents and meets. So what do standard organizations do? Well, so as I said, they're institutional solutions to resolve the transaction cost problems that arise for all stakeholders in an economy, for manufacturers at any point in the supply chain and for consumers who want to use these products, right? And so what it does is, under a set basis of rules, right, they bring together through a collaborative process, the people who know the basis of forming a standard. So it's the engineers, as you heard repeatedly from Jonathan Barnett, and from others. It's this process by which engineers get together and discuss within the context of, well, what will be the best standard we have given the constraints of price, consumer capabilities, and things of that sort, right? Because we would all drive Ferraris if we could, right? But we don't. We have Hondas and Toyotas, because at the end of the day, you don't necessarily get the technological best, but you get the most feasible. And the engineers are the ones who are best able to figure this out. So it's very important to realize this is not a legal process. It's an engineering discussion negotiation process where they get the innovators who develop stuff together with the implementers, the manufacturers, the people who are downstream in the value chain, together to talk about what are the best things that we need. The implementers are saying, well, we have all these costs of production and manufacturing, and we have to design our machines to get these things in the marketplace, and we have wholesalers and retailers who have their demands. They can't, we can't ship these massive products. Personal computers, in the 1970s, a mini computer was the size of a refrigerator. That's why the CEO of DEC famously said in 1976, I see no reason why anyone would want a computer in their home, because he was thinking of the mini computer that his company sold, which was literally the size of a refrigerator that we have now. And so the innovators say, okay, let's try to handle those processes with the technology that we're coming up with so that we can agree on the standard. And by the way, some standards fail. There are a lot, the marketplace is littered with failed standards, just as much as we have successful standards as a result of this. But what you get through the SDOs is trying to create the incentives, balancing between the open negotiations between the innovators and the implementers on what are the best ways to get these products and services into the marketplace. And so you can see the rules that you've heard talked about by all the presenters are geared around structuring to ensure that the process is open, fair, transparent, and leads to the best, most efficient product or service that can get out there. So this is why you have the disclosure requirements. This is why they require transparency. This is why, this is why they, Drat these computers. so this and these and the you have disclosure requirements, and this is also why you heard, for instance, from Professor Barnett, from Jonathan Barnett, how FRAND evolved, right, through this process of balancing the interests between people, where it was recognized that, hey, if we're going to develop a standard and you have a patent on this, then your licensing of this patent should be non-discriminatory. Well, this is how standards development organizations evolve. This is how SDOs came about, how they've been working up until the past several years when tensions have started to develop, where there were growing divides between implementers and innovators. And unfortunately, there was a significant effort and push by, particularly by implementers, to devalue the patents, to make it harder for innovators to contribute and participate in the standard-making process with their patent innovation. And they really engaged in an all-out campaign. They lobbied regulators at the FTC and at the Department of Justice about whether standards gave people too much power. If you had a patent on a standard, we've all heard about this, and theories of hold up, and royalty stacking. They engaged in litigation, and they went to the courts, right? And so and they said, hey, the FTC is investigating these people because they have a lot of power. So you courts, through just pure patent law doctrines, you should be wary about issuing injunctions. And actually, that is now the case. So they've convinced a lot of judges through the rules that govern patent law for remedies and injunctions that it's very, very hard if you have a patent on an SEP, if not next to impossible, to get an injunction anymore if someone is deliberately and willfully and flagrantly infringing your patent. They also pushed for pushing down the royalty base for determining what should be the licensing rates to what's called, in classic patent technical terminology, the small saleable patented practicing unit, the SSPPU standard, right? Which essentially, in plain English, pushes down the royalty rates from what the market had decided for a lot of products, which is device level. So the royalty rates were typically set originally at the device level for foundational standardized technologies. So, for instance, your CDMA technology that's being used in this, that's what makes this a smartphone, right? Without CDMA, this is just a fancy paperweight, right, on your desk. Not even much of a paperweight at that anymore. But so the value of this as a smartphone comes from the standard. And so the market had recognized this and had done device level, meaning phone level royalty rates. And as Professor Barnett talked about, they were relatively low. They're around 3.5%. Well, that was too high for the implementers, who pushed through litigation to have it lowered to the component level, to the chip level, which is pennies compared to the hundreds of dollars that this represents. And that's really significant when you're already talking about a 3.5% royalty rate. 3.5% royalty rate on 2 pennies is a huge difference from a 3.5% royalty rate on a $500 phone. And why be concerned about this? Well, because these rules are all happening ex post. These changes through the antitrust agencies, through the courts, and internally at SDOs, as I forgot to mention. So then at SDOs, famously at IEEE, they went there and they said, well, the antitrust regulators are looking at this. They think this is a problem. The judges all think this is a problem. So we should respond to this and change our rules. And they did. And so they made it next to impossible for owner of patented innovation contributed to a standard at IEEE to get an injunction. And they officially adopted the component level standard for damages for licensing rates, right? So why should you care about this? Okay, so at the end of the day, right, SDOs, as I talked about, are an important innovation. This was an invention, a commercial and technological and market-based invention itself, right? Just like corporations had to be invented, right? To address a problem in the marketplace and facilitating faster and more efficient deployment of new products and services, getting people together, the inventors who invent the light bulb, the people who manufacture the plug in the light bulb, and the ultimate retailers and consumers who are using it, bringing them together to work together. So you have real problems here with concerns about fairness, changes in the rules after the fact, I'm going to go a minute over, right? And concerns about efficiency, because with changes in the rules, that impacts the incentives that innovators have, and that you'll hear, I think, in a bit more detail as the follow-on speakers have. right? And so you end up with a problem. The classic problem in a lot of these organizations, as I said, where they're collaborative and open, and they settle on things usually through democratic voting and negotiation processes. You have a real problem. For those of you who don't know this, this is Jacques David Louis' 1787 Death of Socrates, right? And what's the issue with Socrates is he was voted by democratic majority to drink hemlock to kill himself, and he did. Right? And so here's the concern is that because there's always more implementers than there are innovators, right? Just like there's always more consumers than there are manufacturers. That's just a fact, right? And so you have, unfortunately, people who are using their numbers and their weight to engage in strategic behavior where they're changing the rules that result for innovators in the same equivalent of what's happening to Socrates. And that raises a fundamental concern because it strikes at whether we will continue to have ongoing innovation being deployed through SDOs at all. So, thank you.
Professor Mossoff is the master of subtlety. I've also never seen anyone so excited about standards, and this just really gets us, I'm so excited now, jeez. Greg Werden is Senior Economic Counsel from the Antitrust Division of the U.S. Department of Justice, and I guess I could keep talking while he gets his slides up.
I'm good.
Oh, perfect.
Okay. There's the crucial disclosure that I'm not an IP guy or a tech guy, I'm an antitrust guy, although from time to time I dabble in IP issues of various sorts. And one of the issues has been mentioned in recent years has been standard essential patents. I must say that I was sorry that my favorite standard was not mentioned in the previous talk, and it slips people's mind. It's standard time, which is in fact a standard, had to be agreed on by parties, the railroads, and is still within the control of the Department of, anybody? Transportation. Okay, so this is slightly similar to an article that I have forthcoming, co-authored with Luke Frobe in the Texas Intellectual Property Law Journal. This talk, by its nature of being 12 to 15 minutes, is much simpler than the article. So first lay out the problem with some basic facts. Fact, it is true that lots of owners of standard essential patents have entered into Rand or Fran commitments with the standard setting organizations. They got something in exchange. They got included because they weren't going to get included in the process if they didn't agree to this. And what they have agreed to, it is now understood, but it was not understood when they agreed to most of these things, is that they will license on the terms that would have been reached in what I'm going to call ex interim bargaining, which is the bargaining that would have occurred the day before they agreed on the standard, when they still had a choice among technologies, but when the inventors had already sunk their investments in the inventions. But the implementers hadn't invested a nickel yet in implementation. That's the ex interim period, because one side is invested, but the other side hasn't. Literature sometimes refers to this as ex ante. It's not, because the inventors have already invented. The Fran concept is just that, a concept. It's not a number. It's not a formula. It's not an equation. There is no way that people who are on different sides of the table are going to come up with the same number. It is very much in their interest to come up with different numbers, and they do. So we have disputes. So we have theory of bargaining. It dates to 1950. It's very simple. The parties divide the gains from reaching the agreement. How do they divide them? Well, probably down the middle, but don't worry about that. The important thing is what it is that they're dividing. It's the gains from reaching the agreement, the mutual gains. And in interim bargaining, it's the gains from going ahead and implementing the standard. And with respect to a particular technology, it's the gain from picking that technology over competing technologies. In some cases, you wouldn't have anything without a technology, so that technology would get a lot in the bargaining. In other cases, there are a lot of choices for that particular thing that we could have picked, so that technology would get very little. That's the idea of ex interim bargaining. Some people don't get that some of the technologies are really important and they would get a lot, but that's obviously true. In recent decades, it goes back about 20 years, people have talked about this concept of patent holdup. What this means is that the actual setting of royalties typically, unlike the case we were just told about Qualcomm's original patent licensing, typically takes place long after the standard has developed. It doesn't have to, but it does. So at this point, not only is the invention invented and all the cost of it sunk, but the implementers have already made some of the investments in implementation. And there are reasons why the licensing takes place at this point. A lot of the intellectual property rights haven't really been sorted out for a while after the standard is set. So it takes time to know exactly what it is you need to license. And then you got to enter into the licensing negotiations. All this takes a while. So by the time they're actually setting numbers, investments have been made in implementation. That changes the terms of the bargaining because the gain is now different. Anything that's been sunk, it can't be gained. So there is the potential for the owner of the intellectual property right to expropriate a piece of the sunk investment of the implementer. And doing that is what's called patent holdup. It's, of course, what would happen if there was no commitment and they just bargained after the investments were made, at least according to bargaining theory. The term is used very broadly. It even encompasses a situation where the SEP owner sits down at the bargaining table and puts a number on the table that is later determined to be too high. Well, what's he supposed to do? Give it away? You got to start somewhere in the negotiations, but some people say it's holdup if he starts at a higher number than he eventually gets. There's also something called patent holdout. This term doesn't go back very far. But keep in mind that the SEP owner has made all of the investment before any of the licensing takes place. This is almost inherently true. People generally are not too willing, although it does happen, to take licensed technology when they don't know what the technology is or what it does, and it doesn't even exist yet. Although, in fact, Qualcomm licensed some of its technology on exactly that basis. But it's not typical. So people wait to know what the invention does, how they're going to use it. And by this point, of course, the inventor has sunk all of the investment. It's done. There will be improvements later, but that's a separate story. And so the technology inventor is completely vulnerable. Every nickel he gets is a gain over not licensing his technology. He's already sunk all the investment. He can't uninvent. And so need to determine to describe this situation. And when the SEP implementer refuses to give the SEP owner a fair share, according to bargaining theory, roughly half of the gain, we call that patent holdout. There's also this term, because we needed a pejorative. Holdout wasn't pejorative enough. They came up with this term patent ambush. What is an ambush? Well, when the SEP owner hasn't fully disclosed in advance that he is an SEP owner, which is not really that rare because the standard essential patents aren't all declared well in advance, and sometimes not even when the standard organization requires them to be declared. But the pejorative comes in the idea that all of this is a plan to deceive. That the patent owner kept it all a secret, and sometimes they do, and sometimes for very good reasons. And then when investments had been made, comes forward and says, but you're infringing my patent. Give me money. As far as I'm concerned, there is a very simple remedy to this problem, and it's the remedy that's currently being used. It's called enforcing the FRAND commitment, which courts do. There was some doubt for a while about whether this would be viewed as an enforceable contract. That doubt is gone now. It is. It is enforced. Problem solved. Sometimes the law works. Okay. Our solutions. Well, I'm going to describe 3 different legal domains. They're pretty obvious. I'm going to start with patent law, which manages the incentives to invent and implement and grants patent owners certain rights of action to enforce their rights. Then we have policy toward trade and commerce, which is addressed by contract law, which interprets the bargains that have been struck and grants rights to enforce those bargains. Bargain is actually a great word, and it is used by contract law. Policy toward competition is addressed by antitrust law in this country. I'd love to give you the talk on where the word antitrust comes from. That's for another day. It bars certain anti-competitive conduct and grants rights of action, both public and private. Under patent law, implementers are barred from using the technology without taking the license, but of course, they use it anyway and worry about the license later. And SEP owners can seek injunctions, but they normally don't get them. There's a fairly basic principle of equity, which oversimplified says if it's only about money, then you don't grant the injunction. And of course, it tends to be only about money, but there are a lot of consequences for the money of not granting the injunction. Courts realize that and think it's better not to grant than to grant, but that seems a very arbitrary determination. But the FRAND commitment is cited as an even more powerful reason not to grant the injunction, because we now have a contract that says all the SEP owner wants is money, and he's going to get that. So why should he get the injunction? So injunctions are sometimes granted for standard essential patents, but it's pretty much the exception. So pretty much the only thing left for an SEP owner to do under patent law is sue for damages, which of course you can do and force the issue about what the FRAND royalty is, because it will have to be determined if you sue for damages. But you can get there under contract law as well. If the implementer initiates the action, because the implementer is considered a third-party beneficiary under contract law with rights to enforce the contract between the patent owner and the standard-setting organization. And commentators have long asserted, maybe they'll stop because there's so much contrary evidence, that contract remedies are inadequate, but we have plenty of examples now of courts enforcing the contracts, determining what the FRAND royalty is, and then imposing it as the solution to the bargaining impasse, which is precisely what contract law is supposed to do. If you can figure out what it is that the parties have agreed on, and courts think now they can. They know what FRAND is. Not so sure they do. Another day. Contract remedies do nothing for SEP owners because there are no commitments made by implementers that can be enforced by SEP owners. Finally, there's antitrust law. Many commentators, starting about 15 years ago, started arguing that what we need to do here is apply the antitrust laws. And we have something called Section 2 of the Sherman Act, dates to 1890, and it prohibits monopolization, which I can't begin to explain what that means in the time I have, but it is argued that that is on point here. And the basis for that is that the breach of the FRAND commitment constitutes an unlawful exercise of monopoly power, which harms the downstream device users. I'll come back to whether that makes any sense. In the meantime, I will say that people certainly are trying to use this approach. Qualcomm is involved in a massive treble damage suit in California right now, where the plaintiffs are seeking to recover just about $15 billion. Now, in the few minutes I have, I can't exactly teach you antitrust law, but I can make a few useful points. The history of the antitrust IP interaction is very interesting, but I will give you the 15-second version. These were considered to be two laws trying to do opposite things that constantly clashed. No more. At that point, antitrust was understood not to take away anything patent law gave. Now it's understood that it's trying to achieve roughly the same thing, technical progress through dynamic competition. I'm running out of time, so I'll just mention that the US scheme of antitrust is not about price regulation. Ever, under any circumstances, you cannot violate antitrust law by charging high prices. It is only about competition. Wonderful quote that I don't have the time to read, but in a 1958 decision by Justice Hugo Black, he beautifully explained that all antitrust is about is competition, because we believe that protecting competition will achieve a whole raft of social goals. We may be wrong, but that's why we have antitrust laws. So I get to my punchline, which is that because antitrust is only about protecting the competitive process, it has no scope in these mere disputes over royalties, because nothing that the intellectual property right owner is doing or trying to do is harming a competitive process. There isn't one to harm. And no court decision has said anything contrary to what I've just said. No antitrust claim has gotten anywhere except to survive a motion to dismiss. That's as far as any has ever gotten. Commentators keep asserting something is wrong here because intellectual property owners are getting too much money. They have absolutely no basis for that claim. I find it amusing. We don't know what the right amount of money is, whether they're getting too much or too little. We have no tools to even think about that question usefully. But my gut says they're getting hardly any. The amount the intellectual property rights owners get out of a $500 phone is really quite small. Why is it so small? Oh, thank you.
Left us hanging on that question. And I have Richard Taffet now, who's partner at Morgan, Lewis & Bockius.
Good afternoon. And I am indeed a partner at Morgan Lewis, and I've been involved in a lot of the tensions and problems that the prior two speakers were identifying. And I wish Greg's interpretation of the antitrust laws was recognized more or consistently, I would say, even at the motion to dismiss stage. But I'd like to take this opportunity to take a little bit of a different approach. Typically, when I have to make comments, I have to have evidence behind my positions. I have to prove the points. But today, with the title or the subject of this speech, the future of standard setting, I'm going to take a few liberties and really raise an issue that I think is of extraordinary importance to consider now when we are seeing the tensions that Adam mentioned and that Greg, the problems that Greg is identified with respect to the devaluation of IP and the standards development. And that is, what impact is this having on the public interest as defined by not only US competitiveness, but global competitiveness? And it's a serious issue because it's even arising now with the development of 5G technologies, with the Internet of Things, that there are national security interests that may be involved. And one of the real questions that we, I think, will face and should redefine the debates that have been going on. I will tell you, since 1988, when I spoke at what was called the AT&T Patent Crisis Conference, when AT&T had all the patents and MCI didn't, and they were battling each other, and we went to ANSI to try to figure out what the policy meant, and they didn't have any clue. And everything has evolved from there with very similar arguments. And my thesis for today is we need to move on a little bit and look at what policy positions should be taken to wade through the types of tensions and bilateral disputes between innovators and implementers and the dangers we may face if governments and bodies like ANSI, the American National Standards Institute, become instrumentalized in favor of one side or the other. And unfortunately, they're becoming more instrumentalized in the favor of implementers, which just is exacerbating the problem. So let me just give some background here. As you can see, that standard setting is very complex. Academics like to make models, make things simple, but you have global partnerships, you have industry-specific standards development organizations, as Adam mentioned. You have industry groups, SIGs, which are very focused and have their own rules and operate a little bit differently. But one thing that has, at least from my view, been a consistent need of any types of standards development is a balanced IPR policy. Let the market work in some respects. And this is a quote from Macon Delrahim, Greg's boss at DOJ, where he's identified an unfortunate trend that is happening right now, and that's where SDOs, he calls them SSOs, have adopted approaches that skew towards the innovators. IEEE is one example. We can talk, that's a different discussion we can talk about more. But I think to understand what Macon Delrahim is talking about here is we have to understand the international nature of standards development. And I'm focused really on the traditional standards development by SDOs, as Adam described, who also operate globally. They operate through international partnership platforms such as 3GPP, which is now addressing, as it says here, they started with the WCDMA standard. They went to LTE, and now they're in 5G. You have 1M2M, which is another partnership. I'm going to scroll through these fast. They should be in your book, and I have a paper also in your book. And then you have 1M2M, which is focused by many of the same regional standards organizations, and 1M2M is focused on the Internet of Things and standardization. And you can see that there is the representations of what are called organizational partners in each of these platforms, these partnerships. The way these work is that the actual technical work goes on within the platform, within 3GPP or 1M2M. And then each of the regional organizational partners adopts the specification for their own region. One thing that I think I skipped over a little bit is really important, and it's specified in writing, that the IPR policies of each of the organizational partners need to be harmonized, or otherwise you're going to have a fractured result. Unfortunately, that is now being challenged by at least one antitrust enforcement agency in this country. We'll see how that turns out. So how does this impact the U.S.? So the U.S. is comprised or has a number of SDOs that participate in the global partnerships. We have ADIS that participates in 3GPP. We have ADIS who participates in 1M2M, as does TIA. These are the big telecom standard-setting organizations that exist today. Those are both accredited by the American National Standards Institute. I'm sorry. There's a little bit of confusion about what ANSI actually is. ANSI is an umbrella organization. It does not set standards. It sets policies. And as we'll see, one of the issues that's coming up right now is ANSI putting its thumb on the scale, or possibly putting its thumb on the scale, and there's an unsettled situation right now of how they will be acting in the U.S. voluntary standards development ecosystem to allow, as I mentioned earlier, the effectiveness of in the U.S. of standards development, innovation in the U.S. companies be able to lead in important areas like 5G and the IoT. So ANSI has its own patent policy. And recently, it's come under question. But historically, ANSI's policy has always been viewed as being balanced. I shouldn't say always, in recent times. And one of the things that I think you can find interesting, and Greg touched upon this, the historic view of patents. So in 1932, when the policy was first adopted by ANSI, there was a clear disinclination to include patented technologies and standards. And you can see how that evolved here. In 1967, there's a little bit warmer welcome. 1970, there was even the first time we're seeing now the concept of RAND, reasonable terms and conditions that are demonstrably free of unfair discrimination. And then you get even further in 1990s and the 2000s, where ANSI is beginning to take more of a hands-off role and letting the standards bodies, which are populated by many, many interests who should be competing with each other, both to get their technologies in or to drive the standards process so that they can follow on and build products, as Dr. Jacobs explained, was the success of Qualcomm. Most recently, however, this is, as I was saying, ANSI has interjected itself in trying to interpret what its patent policy means. And in so doing, they issued an opinion, and if you read the paper that's part of the materials, you'll get a lot of the details. But at bottom, the facts here are that a owner of Standards Essential Patents wanted to make a licensing commitment. But the licensing commitment was limited to wholly compliant implementations of the standard, meaning that all of the defined normative provisions of the standard had to be met, or else the patent holder did not have to make a license available. Last September, there was an initial decision which was driven by ANSI staff, which basically said that's inconsistent with the ANSI policy, citing to the IEEE policy, which was explained by others as adopting the smallest compliant component requirement. That set off a firestorm within the industry. So in some respects, the system's working a little bit, that ANSI got pushed back, and there was another decision that was entered where significantly there was an express statement that there is no obligation under the ANSI policy to license at the component level, which would have upset decades-long industry practice of licensing in the cellular space in particular at the device level. It was a practice that has been followed by Qualcomm, but it's also been, Qualcomm was not the first. It arose from the GSM incumbents even before Qualcomm was in the licensing program. So this became a decision that was issued, but that's not the end of the story at ANSI. ANSI formed a task group. And the task group then got to debate what exactly was meant and what should be done. And new directives come out of ANSI at this point, which, from my perspective, can best be described as unclear as to what must be done, where will ANSI go from here. ANSI has to define how it's going to interrelate with the SDOs and adopting the various policies. So we're in a virtual state of uncertainty with regard to what ANSI, which is the private sector designated supervisor or umbrella group for all of U.S. voluntary standardization. It interfaces with the international community as well. And the question is it going to maintain its historic flexible approach, or is it going to start taking this approach that arose last year of trying to put its thumb on the scale and weigh in favor of implementers? So we have some reaction already, which is an interesting development because the ANSI activities drew the attention of the DOJ, again, Greg's shop, and there was pretty consistent statements being made, in this instance by Deputy Assistant Attorney General Andrew Finch, Principal Deputy, basically warning about the antitrust issues that might arising from what we've heard in the past couple of days as a monopsony problem. This letter was received by ANSI. It doesn't seem to have dissuaded their own independent views of how they're going to proceed. But in any event, it does state, as indicated at the bottom, that the Antitrust Division will be skeptical of rules that are imposed by SSOs or by ANSI, which then must be complied with by the SSOs, that appear designed specifically to shift the bargaining leverage from IP creators to implementers or vice versa. So at least the DOJ now, and this is a dramatic reversal from the prior administration and DOJ, who took a very different view and supported the type of approaches to shift the bargaining leverage. Again here, other speeches that have been given by either Assistant Attorney General Del Rahim or Deputy Finch also start discussing a very patent-oriented focus for application to the standards development IPR policies. It's really an emphasis on the fact that SSOs should, or SDOs should be pursuing technical solutions based on consensus or clear majorities, as somebody described earlier today, perhaps, that it's either the lack of sustained objection or 75% approval, and that it should be a very high burden to deprive a patent holder, even if it's a standard essential patent, to be able to get the appropriate return on investment that's necessary to fuel the continued innovation that has really succeeded under the U.S. voluntary standards development process so far. And this is just, we don't have to go through all of these, but again, this is a consistent focus that Assistant AG Del Rahim has pointed to. I think, again, the importance of this is because it does represent a paradigmatic shift in the enforcers' perspectives. I would say that the FTC's new chairman, Joe Simons, has been a little bit less equivocal or more well, he's a little bit less consistent in his commentary. So we're not really sure where the FTC is going. We know what some of the FTC's litigation activities are right now, but at least Joe is trying to recognize the need for some balance here, and I would view that again as a positive shift in the right direction at the FTC as well. We talked about the antitrust duties that may arise in connection with licensing of SEPs. And again, Assistant AG Del Rahim has gone through a lot of the discussion of what the antitrust laws do require and don't require, including, as Greg mentioned, that the antitrust laws, at least as the case law holds, is not a price regulation statute. This comment here, and I wanted to point out this statement here by Megan specifically, because this is where I think the real discussion about the public interest and social welfare really come into play. And in essence, what this commentary raises a dispute that is beginning to get some visibility. There are some economists that speak to this, but it's very different than what most economists would talk about, of establishing the value of an SEP ex ante or ex interim, as Greg had put it. And what Macon is recognizing here is that there is a social value that is established by including a superior technology. And superior could be defined qualitatively, but really is defined through a process. It's the industry's deciding that this is the technology we want to make. And having been involved with this type of activity for decades now, the one issue that I would suggest that I disagree with is it is not a process of competing alternatives. There is a very, very dynamic process that occurs in the development of a standardized technology. And if you happen to have a patent on that and you contributed it, the question is, if you are contributing to tremendously greater social welfare gains than merely the value of your patent, why are you not entitled to at least some percentage, it could be a small percentage, of the value created through standardization? And that's a debate that I think is very, very worthwhile to start having when we start looking at these public interest type of factors to determine whether standardization is succeeding. So here, there's literature that we cite in the papers that we presented, that the hands-off approach, letting the SDOs or SSOs define their policies, it could all work, and sometimes they do fail. And I would submit that the diversity of approach is a real market test to see if they work. There's been a lot written recently about the developments in the IEEE and whether they've been successful or not. I had breakfast with Ron Katz-Nelson, who's written extensively and analyzed whether the new patent policy of the IEEE has succeeded or not. And from my personal perspective, and we can talk about this either in questions or after, what that has proven is that the IEEE patent policy is immaterial right now. People are still developing Wi-Fi standards. They are not licensing, and they are giving negative LOAs. So I think that it's a marketplace development that shows that be careful what you ask for. I'm out of time, and I think some of these approaches or points I've already covered, and basically my view is let the process work, but let's also consider what is it doing for both U.S. competitiveness, global competitiveness, how are the firms who are supplying the innovation going to be incentivized to continue to do so, and let the technology grow. Thank you very much.
Thank you, Richard. So next up now, we're going to have Kerdi Gupta, who's the Senior Director of Economic Strategy at Qualcomm.
Thank you, Adam, and everybody at CPIP for organizing this really nice conference. When I spoke with Adam about this panel, we discussed, as a part of the importance of standards, to raise the profile of an important but rather unglamorous issue sometimes, which is pulling the rug underneath the innovators who invest in the development of future technologies. And that's the issue of the governance rules in standards development organizations, or some people call as standard setting organizations, and why changing the rules ex post matters, changing the rules of the game matters. And it's an important issue for what's coming next in the world of standard setting, what's the future. And we heard the incredible story from Dr. Jacobs during the keynote address this afternoon about how 3G, 2G, 3G, and 4G standards were developed. And there's always this innovation that occurs a decade in advance before the products come to the marketplace, before they're commercialized. And it isn't something that comes out of the blue. And what's next is, I think many of you know this, we are working hard to bring 5G in the marketplace to design and development the next generation technology where you'll be surrounded by billions of small devices talking with each other. And it's another paradigm shift, which isn't just about connecting people, it's about connecting things. And by the way, for those of you who are based in DC, there's a Hill event, there's a Capitol Hill event on on Tuesday afternoon on 5G and its future that a number of people are hosting from Qualcomm that, hope that you're able to stop by, see demos, and learn what 5G is all about. But in this talk, I wanted to talk about the evidence of changing the rules of the game exposed in standard setting organizations, what's happening and why. And I'll just start with this very simple timeline of really everything that we heard about, the story that we heard during lunch, and distill it in one single timeline. And what's the risk like for innovators? When the technology is developed a decade or more in advance, the investment risk is probably at its highest. Why? Because there is competition across standards. You don't know whether the standard you're investing in will succeed or the technology. And the adoption of the market of that technology is unknown. And as you go forward, when products start being developed, there's still a little bit of a risk until when there's, sort of the networks are finally deployed. That's a rough timeline, but it really highlights the issue of where the R&D costs are being sunk. As our other economist on the panel, Greg Werden, put it, what's the real ex ante? The real ex ante is where there's the investment from the R&D side, the sunk cost investments have already been made, then the sunk costs in manufacturing follow, and then we have this ex post universe. And when we reach this ex post universe, if the rules of the games are suddenly changed, that does break the use-create trade-off that is the nature of or the motivation behind intellectual property. So I started my career as an engineer at Qualcomm, working in standards technologies, going to 3G and 4G standards meetings. And then I decided to turn over to the dark side and became a PhD economist. That was a mistake, but I'll try to leverage that in this talk and try to, in this paper that we're working on, and really try to understand in a data-driven way what's happening across different SDOs and why. So the reason, as Adam was, started by explaining within his, because you had so many beautiful pictures, I didn't want to have too many. So this is the most beautiful picture I have, but it highlights what you were saying. It's about the standards organizations are, and by the way, I draw this distinction between the interoperability standards only and these technology standards that I have grown up learning and working on, which is about development of new technologies. It has to bring the right incentives. You have to maintain the right incentives in the rules to attract both innovators and implementers to come together and collaboratively build new technologies. And that's what IPR policies of many major standards organizations like ETSI, which is responsible for organizing 3G, 4G, 5G development activity, says you must provide access to the patented technology to implementers and licensees, but you must also make sure that there's reasonable compensation to patent owners. Why? Because otherwise, standards organizations will become unattractive places for this coordinated innovation. Now, unfortunately, what we are seeing, and I think what some others touched upon, is these changes that are occurring across a number of menu of options, if you will, litigation, antitrust, and certain SDOs, to change the rules of the game in ex post of these standards organizations. And let me just quickly start with IEEE. This is legalese for those people, and I know you're there, who know a lot about IEEE, but I'll just quickly summarize it. It's the changes that were made in March of 2015 were highly controversial, and they were to the effect of reducing the ability of patent owners to enforce their patent rights by reducing what the royalty base should be to one very small part of the big system of the entire wireless system that's needed to function to build a wireless communications technology, down to one small component, the chip, which is a doctrine sort of coming from an evidentiary rule in patent damages, and it wasn't meant to define royalties, and reinterpreting FRAND obligations to something away from licensing at the portfolio level, large portfolios of patents, which is this regular industry practice. And more importantly, really reducing the ability to go to court and seek injunctive relief to enforce your patents. And what happened, I think Richard touched upon it, and Ron has done some research on it too, and we did as well. The market spoke and reacted, and the evidence shows that the patent owners saw these changes. They went back to IEEE and said, we aren't going to commit to license our patents under these terms. And a number of those, Nokia, Ericsson, Interdigital, and Orange, submitted what we call negative letter of assurances, or explicitly denying to license the patents under these terms. So this is a graph over a period of time from IEEE, which shows the change in 2015. And these are all the positive letter of assurances in green that are coming to IEEE And then the red ones are the negative ones, which immediately spike after the policy change takes effect in 2015. So you may wonder how that happened and why that happened, and that's what we're trying to study here. It's really odd because one of the motivations of IEEE was to, it's written here, they said that this update is designed to provide greater clarity. And I think we can all agree that exactly the opposite happened, and it's not good for anybody, because since then, the IEEE Standards Board has approved a couple of standards with this mixed bag of letters of the commitments from licensors. So you as an implementer of these 822.11 AH or AI standards doesn't know whether you're going to get licenses from under the old policy, under the new policy, or not at all. So what did other standards development organizations do at this time? Why did they go down the path of IEEE? Did they make these controversial changes, or did they not, and why? That's the point of this exercise. And when we dug deeper, we have people who go to standards, like 160 plus standards organizations right now. So we brought in everybody and made a table of who are all the standards organizations that you know about that considered the type of policy change that IEEE considered, reasonable royalties based on this SSPPU or the lower royalty base, or limits on seeking injunctive relief, or just taking the IEEE policy change wholesale. And did they adopt or did they not adopt that change? And we found that pretty much nobody else adopted a change like that, except to some extent ANSI, which still deferring that decision to the SDOs and making some clarifications to its changes. But it's not being made everywhere else. So what's happening and why? And the reason is this unglamorous point of the rules of governance, the rules of the game. And here we must pause and realize two things. And I had to really learn this because of coming from the technical side of standards, where the process that is typically followed is open, consensus-based or based on majority voting, supramajority in the room, and transparent. Engineers are sitting in the room trying to decide what's the best technology to meet a certain requirement. And then there's a policy prong, which doesn't always operate that way. Open, consensus, or voluntary, majority-based, or transparent. And when that happens, sometimes we have lopsided policy outcomes. So this is the world that I know. I think that somebody yesterday presented a picture like that. This is a older picture. I thought because maybe Dr. Jacobs will be here, I'll bring a picture from his times when everybody looks really, nicely behaved people, not a big group sitting in this room. Standards meetings aren't like this anymore. There are 400 or 500 people in the room when we are working on 5G. This is also a picture from the headquarters of ETSI in Sophia Antipolis in France. But the point is still the same. When you're making technology standards, it's based on consensus, majority voting, open process. When I've done other research that shows there are 500 or 600 people in the room building 4G and 3G standards, 80% of the contributions came from 9 companies. Handful of companies serve as an R&D arm of the industry. But anybody in the room can raise their hand and say, I don't agree with this technology, or I think it could be better, but it must be based on a technical foundation. It can't be, you're engineers in the room, you care about your reputation with your other, technical colleagues. But this isn't the process that's necessarily followed in the governance rules that define policy. And here's what happened in IEEE and in ANSI, as opposed to these other SDOs that rejected this type of policy change. And this is critical. And others in the room know more about this than I do. So I'm abstracting this to the minimum so that everybody can understand. So in IEEE, there are multiple hierarchies, multiple layers. There's a very complicated block diagram. I just wanted to abstract it to a minimum number of points where a patent committee is responsible for deciding the patent policy change. Usually, that change will go to the Procedures Committee, which will then be approved by the Standards Association Standard Board, which will then go up to the Board of Governors. In 2015, when that change happened, the path changed directly first, not going through the Procedures Committee. Okay. The second problem was these people, the heads of the Patent Committee and actually a lot of people in the Patent Committee, the Standards Association Standards Board and the Board of Governors are appointed members by nominations committees. They aren't voted based on majority. And the process itself wasn't particularly neither open nor transparent. In March of 2013, when Patent Committee started forming the policy changes, a secret ad hoc committee was formed. No meeting notes were kept. Then when it became open for everybody else to comment, there is evidence, there's a paper by Greg Sidak that shows the systematic, statistically significant bias towards the comments of those that weren't in the committee. They were twice as likely to get their comments rejected on this draft than those that were in the secret committee. And then the approvals happened, denying, appeals on the procedural grounds. Remember, we bypassed the Procedures Committee. And then the DOJ issued a business letter based on the risks of patent holdup, which our, DOJ's economists are now saying maybe a suspect theory, and IEEE formally approves the policy. And ANSI, something similar happens. Usually the IPR-PC is responsible for policy changes, IPR Policy Committee. Everybody who cares about IPR goes here. Suddenly, as of May 2017, a lower in the hierarchy body called the Executive Standards Council becomes responsible for interpretation of the IPR policy, and a new path is generated. So that, I don't have the last slide here because we couldn't update it, but I had this picture of a room with, filled with smoke and people sitting in a room with board of directors of the old railway company in the 1800s and deciding, rules of governance, as opposed to this this nice picture where everybody is deciding openly what to do and how to, build a standard. And I think we can all agree we want this and not that, both in the governance and in the technology prong. So let's stop here.
Okay, so we have about 15 minutes for questions. I first wanted to see, Adam, do you want to have some discussion among the panel first? Or should we just go right out to the audience? Some hands ready, if we have microphones.
Thanks. I have a question about competition between or among different standards and different SDOs. So Adam gave a great presentation showing the value of standards, so we clearly need them. But sometimes I think it may be useful to have more than one standard and have a bit of, let them slug it out in the marketplace. I mean, standards then can die in the marketplace, and DC was actually implemented as a distribution method for power, but in the marketplace it lost out to AC, so that was good. Dr. Jacobs told us over lunch how, fortunately, he was able to get an alternative standard into the US system, but was actually closed out from Europe. Now, had he not been able to get it into the United States, the world might still be stuck with TDMA, perhaps. That technology would never have been adopted at all. It probably would have come eventually. CDMA would have come eventually. But so I think there's some benefit at the technology level, having both different standards and different SDOs. And actually one basis of competition between SDOs could be IPR policies, different IPR policies. I share the same reservations that Kirti does about the process with IEEE. But as an experiment with an alternative IPR policy, well, let's see what the market comes up with. I mean, Bluetooth, for example, special interest group, royalty-free approach, why not? And it has its place in the marketplace. My concern, though, is, for example, with the IEEE policy, it then kinds of, it sort of gets adopted or in a way that it sort of taints the whole environment, and there's some sort of expectation that chip-based licensing should be kind of universal. So there's a concern of mine, and maybe others of that. So, can we have different IPR policies? I mean, Richard, you were saying that there's some need for harmonization. So how harmonized or monopolized can we afford to be? So with cellular standards, everything is now with 3GPP. So we have one large entity that's kind of doing everything. So my question, so those are my comments. My question is well, how I'd like be interested in some comments really on competition among standards and amongst SDOs. What sort of prospects or future do you see for that? What would be a healthy environment?
So let me, and I'll try to unpack your commentary as well. So I really do think that we have to look at this not on the theoretical level, because to make the easy statement, sure, let the market just do what it will do and people can propose whatever policies they want, we'll see how it works out. Lovely. But that's not real. And I think, for example, that there is a tremendous need to look at, for example, when is that policy change being made? You have to remember that in IEEE, what drove the policy changes in 2007 and 2015 was all in the Wi-Fi space, 802.11 for the most part. And the IEEE started developing 802.11 in 1999. People had established expectations as to what the rules of the road were going to be, and the rules of the road were going to be changed in mid-course. And by that time, in 2007 and 2015, I would assert to you that the IEEE had market power in the development of Wi-Fi standards. That's a hugely different circumstance where, for example, you have a Bluetooth SIG that's developed at the outset, saying, you want to join, we're going to address these types of very specific types of specifications, here's our rules. Or the W3C that was developed for the internet type of standards. When they were developed, it was a greenfield, and it went forward. The last comment I would make is, and my point about harmonization comes about from a different perspective, where you do have a 3GPP, where you have the regional SDOs from, I think it's 7 now, regions. And you have one M2M, which is machine to machine, which has basically all of the organizational partners from 3GPP and all the organizational partners from 3GPP2, which is more the CDMA side of the coin. And the rationale for harmonization in that regard is that all of these standards are global in nature. And cellular communications, I mean, I remember back in the old days when there had to be, I don't know the technology, but I remember standards being developed in ATIS, specifically because you get closer to the border of Mexico, and all of the things started going haywire. We don't really have that problem right now because you have chips or technology that is global. And if you had distinctions between regions, the uncertainty that would arise of how do you do business? How do you do your licensing programs? How do you develop a worldwide licensing program would stall the ability to have the adoption and the widespread, not only adoption of the then existing generation of technology, but as Kirti suggested, that it takes 5 to 10 years to get into the next generation. People are just beginning to think about 6G now, and 5G hasn't even been finalized yet. We know that even in Wi-Fi in the 802.11ax, there's product that will be out either at the end of this year or the beginning of next year, and that standard isn't even final yet. So people are building well in advance of approval of that. So this is what I talk about. There's all of this nice discussion in which I've engaged in also about this interest and that interest and the policy issues and all those kind of things. There's a practical reality that people have to build product. And if you raise the upfront costs too much through this type of nice, charming competition among standards policies, I think without looking at the details, you run into problems. But that doesn't mean, and there do exist right now distinctions among different types of policies. My answer was almost as long as your comment.
Unless I see, I also want to say that there's you have to take into account another aspect of what Richard is talking about, which is the real-world incentives and of the strategic behavior that occurs, right? So, because it's not just what's happening at the standard development organizations, as you heard, right? It's strategic behavior with respect to law and regulatory policy, and then using that as a feedback mechanism back into the SDO itself, right? And so when you have a successful pattern of that occurring at the IEEE, right? So where implementers are going to Renetta Hess, the former head of the antitrust division at the DOJ, and telling her, we have a problem, we think there's a problem, you need to take action on this. She starts giving speeches, then they take those speeches and go back to the IEEE and see, the government agrees with this, so you need to adopt this. And I was at a conference 3 years ago at a public conference here in DC, where Renetta Hess was asked, so what evidence do you have of actual systemic problems of patent holdup with respect to standards in the innovation industries or the telecom industry in particular? And she had two responses. Her first was, I can't disclose it because these are secret meetings that we're having per the rules of the confidential meetings, what everyone else would call secret. So I can't disclose who's been coming to talk to me. And she said, and then when she was pressed on, but what's the evidence then, other than the fact that you've been told by individuals who clearly have an interest, short-term commercial interest in lowering their manufacturing costs? And she said, well, at the end of the day, you have to do what you feel is right in your heart. And so we have literally
there's another example of that where the former chief economist of DOJ. Sorry, Greg, we're picking up your organization. To answer the same question, put up a slide of what I was told is supposed to represent, black hole or something?
Dark matter.
Dark matter. And said,
That's
what holdup is. Same concept,
can't-
really in-depth, hard analytical abilities from our former leaders.
So, for instance, I'm not surprised to see the same pattern of what you saw at the IEEE occurring at ANSI, because it worked, right? I mean, and so the incentives are now to replicate that because it worked. That's what got them to achieve it in IEEE, and now they're going to treat. And so if you say, well, but in theory we can have compete, yeah, but that doesn't take into account the real world nature of the institutions and what's occurring.
But, I mean, taking a step back, in terms of the technical standards and there being competition, I think that's an approach the US took long ago, starting with the 2G standards, TDMA versus CDMA, and let the marketplace decide. But in terms of policies, the problem isn't so much as should there be competition across standards. The problem is, I think what both of you are talking about, is the changing of the rules after all the sunk cost investments have been made. And, in the literature of economics, that's called holdup.
I'm afraid we've gotten a little away from the idea that engineers sit around a table and make technical standards, but that idea has a lot of merit. They don't care about anything but solving a technical problem, and they will come up with what they think is the best solution. And a lot of people may want to adopt that solution. Nobody has to adopt a standard, but they will be given the opportunity to adopt the standard. And if we don't have those guys sit around, we will probably get several other technologies on the market that aren't quite as good, and we'll settle for those, and we'll have less interoperability and more monopoly. Because when you have a standard, then you have 100 implementers competing to implement the standard better than the other guy, which works very well for consumers. Whereas if you have proprietary standards, then one guy owns it,
That's right.
and he'll do what he wants with it.
Well, and that's a really important point when we look to see what is the future of standards development right now. Because one of the things that, it's all confidential, so I can't disclose the details here, Adam. But you have this disincentive to participate.
Yeah.
Because you're basically making all the investment that you have to develop new innovation. And you want to then build a business model along that way. And if you're not going to be able to do that, what's the alternative? Well, it could be either through a SIG, a special interest group, for example, or through a de facto approach to adopt proprietary standards. And you lose the whole benefit of the open, transparent type of process that Kirti was describing, which allows for the expansive adoption of the new technologies.
Okay, so let's try to get one more question in. Maybe go to this side of the room first, Ron, and then back.
Ron Katz-Nelson. It's a question for Greg and maybe even Kerdi. You indicated earlier that the theoretical framework of an ex-ante situation is that the standard or the technology purveyor has a choice, and he's trying to basically position itself to have its technology accepted. But there are two questions about that. First, you mentioned that the indication what was done with Qualcomm, what Irwin discussed, the fact that he already had some licenses prior to committing to FRAND commitments is an unusual exception. I would submit that the exception is the other way around. It's very risky for a technology purveyor to, up front, not having negotiated any licenses, to say, I'm going to license under FRAND, non-discriminatory, not even negotiated a single case, not even knowing what would be the terms that will come out. I suggest to you that the DOJ needs to think a little again about the concept of FRAND, that a lot of those decisions before FRAND is committed to are made before even submission to the standard or even before committing to a FRAND. Because I know I negotiated with two guys here, and I know I can trust that that kind of term I can claim won't be discriminatory. It's hard to make a non-discriminatory obligation without having a concept of what it would be like in which a customer would agree to. So many of those announcements are made after initial licensing already took place. Does that change your way of thinking about these ex-ante exposure that might have been there?
Not really. From a theoretical perspective, the ideal solution probably is very, very different from FRAND. It is for intellectual property owners to commit to actual numbers before anybody adopts the technology.
But numbers are not, it's a vector. It's not just numbers.
Well,
It's
it may be a
reciprocity,
complicated.
it's a portfolio.
It may
I
be
mean,
a
it's not a number.
complicated contract, but you can write it.
And that's what I'm saying. People do that.
And
Before-
it's a good solution, but it's frequently not the solution that's been adopted.
But it's not, in the sense that if you look at the 2007 IEEE policy change, where they permitted the disclosure of maximum terms, we know that one company in history disclosed, quote, maximum terms. And there's good reason for that. I think partly of what Ron is suggesting is that I don't want to lessen my licensing freedom and negotiation freedoms by locking myself into that cap. And second, if I'm negotiating with you versus negotiating with Kirti or negotiating with Ron, you all may want something else. So in some respects, you're also limiting the licensing freedom of the implementer. Because implementers, yes, we heard about, most favored nations clauses, and that's the way to protect against that. But, money's more important to some than others, and they can trade off, and they can have cross licenses, and they can have, choice of law maybe is of some monetary value.
To plug a prior conference that we did, so former FTC Commissioner Joshua Wright actually gave a talk. It was published as a paper on incomplete contract theory as applied to FRAND, explaining why the factors and just as a descriptive matter, the efficiencies achieved through what must by necessity or I should say, best choice be is incomplete contracts, not specifying the terms. Because the problem is you don't know where the innovation is going to develop and how it's going to develop and what the value of it will be. I mean, I think that was clearly made by Dr. Jacobs, they, in 1990, when they were driving around in their van, I mean, if you said, hey, in 30 years we're gonna have these devices in our pockets that will be the equivalent of your van. And
I think the absence of perfect foresight is very important. Economist solution to contracting problems are all very theoretical and probably not implementable. But there's certainly a lot of merit to prior commitment. I predicted, it just turns out wrongly, for a long time that FRAND commitments would not be enforceable because they are too incomplete. They do not have a price term. There was no meeting of the minds between the inventors and the implementers about what it meant. We know that because when they got into a room and put numbers on the table, they were miles apart. Not surprisingly. For some reason, the implementers thought it meant super low royalties. Because somewhere there must be an S and a U in that FRAND, which I can't find. But FRAND meant super low. And to the inventors, it didn't mean that at all. It meant, I got a really good invention here and I want my money.
Meanwhile, tens of thousands of licenses have been entered into, and the number of disputes that have arisen is de minimis. So something may be working out.
So-
Well, I don't think it's completely working out. It's not an area of my specialization, but when
Yeah,
I
we're
look at the
running out of
decisions that have been made
time.
to set the royalties,
I'd like to
they
let
seem
Kirti
too
be able
low.
to get a word in here edgewise. No, Kirti, you- please.
Oh, well, okay. So allow me to suggest something, an alternative here. So starting from the basic economic theory, I mean, this is bargaining under incomplete contracts. And when that happens, we've had a history of successful contracts, successful industries when there have been incomplete contracts. And that happens because both parties are making a commitment or both have an incentive to negotiate. And in the FRAND context, at least there are some courts, like the Court of Justice in the EU, that has made some clarifications about obligations that are necessary on both sides, both licensors and licensees, in the context of ability to seek injunctions. But maybe it's time to take a step further and think about not just licensing commitments from licensors, but some sort of commitments also from potential licensees before all of these asset-specific sunk cost investments have been made.
Let's leave it on the last word. Please thank our panelists.
Kirti Gupta.